Good afternoon, everybody. You are all very welcome to the public lecture called Adult Safeguarding, a Rights-Based Approach for Older Persons. My name is Bibiana Savin. I am the CEO of SAGE Advocacy and also a member of the Irish Gerontological Society Executive Committee. I am delighted to welcome you to this public lecture on behalf of IGS. And this lecture will address issues such as Advance Healthcare Directives, Deprivation of Liberties, decision-making arrangements under the assisted decision-making capacity legislation, and the role and obligations of those interacting with persons who may be at risk. We are very fortunate to have with us today a panel of professionals, which I will be introducing on the second part of the lecture. But for the moment, we will start the lecture with Patricia Ricard-Clark, who is currently the chair of Safeguarding Ireland and a trustee member of the board of SAGE Advocacy. She's a former commissioner of Law Reform Commission and currently is a member of the Department of Health Advisory Group on Protection of Liberty Safeguards, and also a member of the National Disability Authority's Research Ethics Committee on discharge of the court process. I think you'll all find this event very informative. I'm hoping that will be the case. And we received a lot of questions at the beginning from the public, and we will encourage you to continue to do that for the duration of the lecture. So at the moment, back to you, Patricia, and thank you very much for agreeing to be with us today.
Thank you very much, Bibiana, and for inviting me. So if I can move on to the slides. Emphasis on older people. And what is safeguarding about? It is really about respecting each individual as an individual with their own independent rights. Again, as Bibiana said, I'll be talking about Advance Healthcare Directives. So we need to protect ourselves. So we've obligations to make arrangements to do so. I'll be briefly talking about deprivation of liberty, the current situation with regard to that. Obviously, people are living longer and there's more than need for a person to have final place of care. So a very important issue in terms of constitutional right. The Assisted Decision-Making Capacity Act commenced last April 2023, and it actually has put in place, it replaces the old wardship regime and has a number of arrangements in order to assist a person, obviously to plan in advance, but also to support them in making their decisions and to exercise their rights. I'll be briefly talking then about the Law Reform Commission report. The Commission, I should say, there is no adult safeguarding legislation in place at the moment, and the Commission produced a report last April making recommendations for a robust framework around adult safeguarding. So if I can start then, say that in current policies and practice, we are now talking about a rights-based approach when we're talking about safeguarding. And what a rights-based approach is again, ensuring that rights are respected, including the right to autonomy, dignity, bodily integrity, privacy, control over a person's financial affairs and property, non-discrimination, equal treatment in respect of access to goods and services, and respect for beliefs and values. And when a person gets older, sometimes we actually step in, make decisions, and don't respect their right, and they respect their right either to equality of treatment to services. Very important issue. The Assisted Decision-Making Capacity Act was the first piece of adult safeguarding legislation actually that we have. And again, as I said, it replaced very archaic legislation. It sets out a number of principles which we must abide by, again, to respect the rights of a person. So regardless of any diagnosis of illness or whatever, we must start with a person, that person has a presumption of capacity. And then, so far as practical, to ascertain their will and preferences, and then to support them in exercising their rights, but also support them in making decisions where their capacity is in question, or where they may lack capacity. The Law Reform Commission report sets out a framework, as I said, for adult safeguarding legislation. It follows a lot of the principles in the adult safeguarding, in the Assisted Decision-Making Capacity Act, but also sets out again the importance of systems to be put in place to protect people against abuse and to prevent abuse happening in the first place, and then in terms of obligations in relation to that. So the Law Reform Commission defines safeguarding as a measure that should be put in place to protect the safety and welfare of adults and to ensure that they're not at risk of harm. So it's to minimise the risk of harm, but very importantly also to support adults to protect themselves from harm. You would see there at the bottom of the slide that Safeguarding Ireland did a survey in November 2022, and 75% said that there was a greater risk of abuse where another person made decisions on behalf of a person who was at risk. So really important that we do protect ourselves as well. And again, the Assisted Decision-Making Capacity Act provides for two very important planning in advance tools to protect ourselves against abuse. So there is legislation on making an enduring power of attorney and an Advance Healthcare Directive, and we're waiting then on legislation for a place of care decision. So I'm going to talk now about Advance Healthcare Directives. So an Advance Healthcare Directive is an advanced expression of the will and preference made by a person when they have capacity concerning treatment decisions that may arise in the event the person subsequently lacks capacity. As we all know, a healthcare professional does require our consent to administer treatment to us. Again, the whole question of constitutional right to bodily integrity, and if there's any intervention in that, then our consent is required. So the legislation sets out the purpose of making an Advance Healthcare Directive is to enable persons to be treated in accordance with their will and preferences, to provide healthcare professionals with important information about the person in relation to their treatment choices. That's extremely important and has given rise to huge difficulty for family members, again, dispute amongst one another as to what mum or dad would like or whatever and what are their choices, and probably making decisions that mum or dad does not agree to. So really important, again, that we put measures in place ourselves to protect ourselves and to make sure our wishes are respected. It must be made by a person over the age of 18. So it's about really a person is entitled to refuse treatment, regardless of whether it's based on religious beliefs, if it appears to be unwise, or it appears not to be based on sound medical principles or may result in a person's death. But we'll come on to some of those issues. Sorry, I'm having difficulty moving on these. Sorry, yeah. So again, the Act defines what treatment is, and it says it means an intervention. So it's talking about an intervention to the body, an intervention that is or may be done for a therapeutic, preventative, diagnostic, palliative, or other purpose related to the physical or mental health of a person, and it includes life-sustaining treatment. It also includes artificial nutrition or artificial hydration, for which consent is required. Again, it has been a practice in the past to ask family members or next of kin to sign a do not attempt resuscitation order. That is not correct. Again, the person must be asked to consent themselves. And of course, the Medical Council guidelines expand the definition of treatment as well, which says that it includes assessment, investigation, and treatment. You cannot put into or make an Advance Healthcare Directive where a person is refusing basic care. And basic care is warm shelter, all nutrition, all hydration, and hygiene measures. But again, I'm emphasising basic care does not include artificial nutrition hydration, which is an intervention and does require the consent of the person. And again, an Advance Healthcare Directive is planning in advance to consent or refuse treatment. It does not affect the existing law on euthanasia or assisted suicide. Euthanasia is the deliberate taking of life. Assisted suicide is assisting somebody to take their own life. There are certain formalities that must be complied with. It must be in writing, and it can be revoked or altered. It must be in writing, signed and witnessed. And again, there's provisions in the Act that it can be signed on behalf of a person who is unable to do so themselves. So again, the making of an Advance Healthcare Directive, a person can simply write down their advanced wishes, healthcare wishes, but again, it must be signed and witnessed, or they can appoint somebody, which the legislation calls a designated healthcare representative. So again, there are templates both in the Decision Support Service website and also the template on the Think Ahead website, the Hospice Foundation. Again, I would emphasise that the Decision Support Service website has detailed codes of practice and also detailed guidance, not only on Advanced Healthcare Directives, but on all other arrangements under the Act. So really important to tap into those arrangements or details. So the purpose then of an Advanced Healthcare Directive is to enable a person to be treated according to their will and preference. And again, to enable a person to safeguard themselves by putting in place a measure that communicates their will and preference. Again, very important, particularly if we have a chronic illness, if we have an allergy to particular medications, etc., that when we're no longer in a position to verbally tell our healthcare professional that at a particular time, that again, we include those issues in our Advanced Healthcare Directive. Again, to emphasise the HSE consent policy, and again, not only is it important for healthcare professionals to know our will and preference, it's again important for family members and those around us to know exactly. It avoids a lot of stress and anxiety at a critical time when somebody may be very ill. So really important reasons why one would put one in place. Again, coming back to the appointment of a person who is to be a designated healthcare representative, it is the named individual. Again, under an enduring power of attorney, a person can appoint more than one person. Under a designated healthcare advance directive, it must be a named individual. And that's really important because, again, a person must have authority and not have a dispute between a couple of people as to what mum and dad's healthcare wishes are. Again, the person that's appointed must agree to act in accordance with the will and preference as determined by reference to the directive. So they don't have just carte blanche to make any decisions about healthcare. Very important. They act as agent. That means they act in compliance with the wishes as set out in the directive. And again, they only have the power to exercise that authority when the directive maker lacks capacity. They cannot delegate their power to another person. However, in the making of a directive, a person can appoint an alternative to act if the original person that's appointed is no longer able to act, or they have predeceased the person or whatever. Again, the designated healthcare representative is obliged to ensure that the terms of the directive is carried out, and also to advise and interpret the will and preference of the person. Again, look at the wording in accordance with the terms or by reference to the Advance Healthcare Directive. And again, a healthcare representative can be given the authority to consent to or refuse treatment of the directive maker. Again, really important that somebody has that authority to make those decisions. Again, the Advance Healthcare Directive, a person can refuse treatment. And again, a treatment refusal must be complied with by a healthcare professional if 3 conditions are met. The Act sets out that 1, the person lacks capacity, the treatment to be refused is clearly identified, and the circumstances in which the refusal of treatment is intended to apply, again, is clearly identified. So no good saying a valid Advanced Healthcare Directive would not be, if I have an accident, I don't want any healthcare treatment. So again, the treatment must be clearly identified and the circumstances around that treatment. Again, In some jurisdictions, when people make an advanced healthcare directive, or a living will, as they're called in some jurisdictions, there are time limits put on that. Our legislation does not put a time limit. So even an advanced healthcare directive made a couple of years ago will still be valid and effective if it's relating to the treatment that's being dealt with at the particular time. Again, an extra protective mechanism, if you like, or safeguard, is that if a person is refusing life-sustaining treatment in their Advanced Healthcare Directive, then it must be substantive. The maker, when making that directive, must set out a statement that directive is to apply to the treatment, even if their life is at risk. So an important safeguard. A request for specific treatment in a directive is not legally binding. It may not be clinically indicated. It may not be practically possible to comply with a health treatment wish. But however, the Act is very clear that even though it's not legally binding, it should be taken into account if it relates to the specific treatment that the person is having at that time. And again, it must be documented. There must be a record kept of the reason for not complying with the directive, and a copy given to the designated healthcare representative within a time period. Also, a copy if a person maybe lacks capacity. They may be going through a particular health issue, lack capacity, but subsequently may have capacity. So they may want a record of what decision was made and why it was made. Again, an Advanced Healthcare Directive applies to all physical health and mental health generally. There is an exception if a person has a mental disorder and is receiving treatment under the Mental Health Act. So again, if a person has a mental disorder, is receiving treatment under the Mental Health Act, or is subject to a conditional discharge under the Criminal Law Insanity Act. But of course, a health treatment refusal in an Advanced Healthcare Directive, which relates to physical illness and not related to the mental disorder for which the person is receiving treatment for, is perfectly valid. So my Advanced Healthcare Directive dealing with my physical treatment, even though if I have a mental disorder and I'm receiving treatment for that mental disorder. Now, again, there was a lot of debate, and indeed there was an expert group looking at the whole issue of the revision of the Mental Health Act, and there was a mental health bill which went through the Oireachtas. It went through legislative scrutiny in 2022, and so this issue has been raised for review and for reform. And I just see 2 days ago that the Mental Health Bill of 2024 has been restored to the Dáil and Shannon order paper. So it will be debated further. So again, that issue is due to be debated. So again, an Advanced Healthcare Directive is not valid if it's not made voluntary. In other words, if a person is forced to make a directive or is forced to actually appoint a particular person as their healthcare representative. But again, it's not valid while the person had capacity, has done something clearly inconsistent. So for example, say, and we've had a number of cases where a Jehovah's Witness has refused blood, but supposing they then are admitted to hospital and decide they will have blood next time they come in, that has been inconsistent and not consistent with what they've set out in their directive. So in that case, it would be deemed not valid. Again, it might be not applicable where the person has capacity to consent. And again, the treatment in question is not broadly recognised as set out in the directive. In other words, it's not clear. And again, the circumstances are quite different. So really important that specific treatment and specific circumstances for it to be valid and taken into account. If there is ambiguity, again, the Act sets out various course of action that has to be followed. Again, a healthcare professional may consult the designated healthcare representative and indeed maybe family member to ascertain the will and preference of the person or seek another opinion. And again, it may be reference to getting legal advice and refer the matter to court. Obviously, if there are very significant issues that may have an effect on the future life of the person, like the amputation of a limb or whatever. Obviously, that's very serious, and we don't have court cases yet to determine what action should be taken, so it should be referred to court. But in the meantime, if there is disagreement, obviously the Act says that the professional shall address any ambiguity in favour of the preservation of the life of the directive maker. Again, there's liability, civil or criminal liability for breach or not following through on the Advance Healthcare Directive. Obviously, there can be no liability if the healthcare professional had reasonable grounds to believe and did believe that the refusal was not valid or applicable, or they were unaware of the existence and the contents of the directive. That could arise very much in an emergency situation or whatever, not aware. Again, if we have a lot more of this now, people coming from outside the state, particularly older people who've been living in England a long time, they may have made a directive there. Is it applicable here? And again, the Act provides, again, if it's really substantially complies with what's set out in our legislation, it should be recognised. So an important provision. The Act provides that the Minister may make regulations requiring the directive maker to give notice to particular people, including notice to the director and to other specified people, which are mainly family members. And also to make regulations requiring the director of the Decision Support Service to establish and maintain a register. Again, a register is extremely important. So again, a healthcare professional can have access to that and see and get a copy of the relevant directive. But to date, no regulation has been made. I just note there that last May, the Minister for Health did set out that there was going to be an app where people would receive and have important information about their medical history and records. I really do feel that we do need that register so we can register our Advance Healthcare Directive, because that's absolutely vital that healthcare professionals know about that. Just to say, again, Safeguarding Ireland did research late last year, and we're doing a campaign at the moment to try and encourage people to make an Advanced Healthcare Directive. Only 4% of the population have made a directive, and many people really don't understand why they should. Most common reasons you'll see there: never thought about it, no current healthcare problems. And that's a huge misunderstanding, I suppose. Any of us could have a serious accident tomorrow. It's not related. Again, people say too young to make one. We should not wait until the critical time where maybe we lack capacity or we're too old and frail and don't understand. So really important that we do that. Again, some said it was too expensive to do. It doesn't cost anything to make an Advanced Healthcare Directive. And again, really important that people tap into the Decision Support website, get the template, get the code, and get the guidance document for making that. So moving on then to deprivation of liberty. So again, just putting up a slide that again, Safeguarding Ireland did a survey on preferred place of care, and you see, and it's well known anyway, many surveys have been done on this. The preferred place of care is one's home. So again, moving down, you see hospice care, again, actually much preferred to, say, nursing home. So a whole question then of people living older and being put into a place of care that they're not really in agreement with. Again, as part of that survey, we asked the question, what do people think? Can a family member or a friend make decisions on behalf of a person without their consent, even if they have capacity to make those decisions? And you'll see a very large proportion of people think that those decisions could be made by another person on behalf of a person who actually had the capacity to consent. So really concerning. So it's important that we do respect a person, particularly older people have a right to express their will and preference. So just to say, the whole issue of putting a person in a nursing home is against their wishes can be a deprivation of that person's liberty. We've very clear constitutional law provision to say that no person shall be deprived of their personal liberty save in accordance with law. We don't have any piece of legislation at the moment setting out arrangements for care arrangements to put a person in a place of care without their consent. So really important that we've that big gap in our legislation, but we have that constitutional right. So again, under the European Convention of Human Rights, again, it specifies a person cannot be deprived of their liberty except in accordance with the procedure prescribed by law. And we enacted in 2003 an act to say that we would actually interpret all our policies and indeed our legislation and court decisions in accordance with the European Convention. Again, we haven't put that into practice. And again, under the UN Convention on the Rights of People with Disability, again, it says a person shall not be deprived of liberty except in accordance with conformity with law. And again, that UN Convention, of course, is the basis for our Assisted Decision-Making Capacity Act. We had a case going before the courts in Sharan for a couple of years. It was a lady who had been made a ward of court, and again, she was put into a nursing home, and again, her family argued that she didn't want to be there. They wanted to take her home. So again, just looking at some of the comments of the court, it's a right under the Constitution which cannot, and this was under the wardship regime, of course, it's a right under the Constitution that cannot be swept away by Victorian wardship legislation. It's a legal issue and not a medical issue. So again, reciting the constitutional article to say that all persons cannot be deprived of their liberty, and again providing that an application can be made to the court. Again, there isn't a paternalistic entitlement to act in the best interest of a person. Again, just to note, we don't look to the best interests in the Assisted Decision-Making Capacity Act. We have our various principles, and then we act in good faith and for the benefit of the person. So not what we think is in another person's best interest. So again, if a person is being deprived of their liberty, that was the Court of Appeal. I gave you the comments there. It was appealed to the Supreme Court, who held then if a hospital concludes that a person lacks capacity to make a decision, and if they have concerns about the welfare of the person, then they must make an application to the court within a reasonable period. And that period was indicated by the Supreme Court as 2 weeks. In the meantime, the court said that the doctrine of necessity could be applied, but again, that was only a temporary situation. So again, the court said if a patient lacks capacity, the hospital must bear in mind that it has no general power of detention. So quite recently then, since that case, there are a lot of cases where it is necessary to maybe make an application to the court where a person hasn't set out clearly or it's not known what their wishes are. So again, the court very clearly saying that a person who lacks capacity are protected by the same constitutional guarantee as any other person. So really important comments by the courts. And because we have the situation where we don't have specific legislation to apply, then we have a situation now where if a person lacks decision-making capacity, it's an application to the Circuit Court. The Assisted Decision-Making Capacity Act it deals with capacity decisions and capacity issues arising in relation to a person who lacks capacity. But the Circuit Court cannot make, because it's a constitutional issue, the Circuit Court does not have jurisdiction to make decisions about detaining a person. So in that case, the High Court has what we call an inherent jurisdiction. In other words, it has discretion where there isn't specific legislation dealing with a particular matter. It can make a decision. So we have now that situation until we have clear legislation to allow, if there's an application going before the Circuit Court about capacity, that it can also deal with the issue of deprivation of liberty. So again, just making the point that, again, treatment and care decisions are very distinct from place of care decisions. So again, that place of care, deprivation of liberty, constitutional issue at the moment, it must be dealt with by the court, and it must be the High Court. Again, the Health Act, just as treatment, you can't make a treatment decision in enjoying power of attorney. You can only do it in an Advance Healthcare Directive, and the Advance Healthcare Directive says in terms of treatment, then if your treatment relates to your mental disorder, at the moment, until we have revision of the Mental Health Act, you can't include an Advance Healthcare Directive. However, in a number of cases, it may arise that a person lacks decision-making capacity and also has a mental disorder. So there's provision then in the Assisted Decision-Making Capacity Act in relation to detaining a person, either putting them into a nursing home or whatever, that if they have a mental disorder, it is the Mental Health Act that applies. So the detention takes place under the Mental Health Act. So you see at the moment, we really need very specific legislation to bring clarity to these points. However, again, the Assisted Decision-Making Capacity Act, there was an amendment to that act, which was enacted in 2015, although not commenced until 2023, but there was an amendment act in 2022, which set out to say that nothing in this act shall affect the inherent jurisdiction of the High Court to make orders for care, treatment or detention. So just again, to clarify that. Again, in the government's spring programme, you'll see there's Protection of Liberty Safeguards Bill, and there's a Health Adult Safeguarding Bill for the health and social care sector. So moving on then to the arrangements under the Act, which are all again, there are 5 different arrangements. So first, when a person has capacity to make and to plan for the future, they can make an enduring power of attorney, and they can make an Advance Healthcare Directive. And under making an enduring power of attorney, they appoint a person called an attorney. It can be a friend, family member, doesn't have to be a family member, a person they trust and they choose. Again, a designated healthcare representative can be a family member, doesn't have to be, can be a friend, again, a trusted person. Again, when a person's capacity is in question or may shortly be in question, a person may just have got a diagnosis of dementia, for example, but they're still able to make decisions, maybe with support or whatever, but they may be able to make them themselves with help. So there are 2 arrangements there when a person is in that situation. So a person can appoint a decision-making assistant under a decision-making assistance agreement, or they can appoint a co-decision maker where they're a little bit more challenged to be and have a co-decision-making agreement. And alternatively then, if they have made no arrangements, or even if they have an EPA or an enduring power of attorney or Advance Healthcare Directive, but they don't contain the particular decision that has to be made, then it's an application to the court. So it's really important that we're not running to the court, that we have planned in advance so far as we can. And certainly a lot of cases that came before the court in the initial days back in 2023, a lot of applications in relation to that application for the Fair Deal scheme. Many people didn't have I suppose, a lot of finances or property, but in order to get the Fair Deal home loan allocation or whatever, it was necessary for that application to court. So really important, even if we have sort of minimal finances or minimal property, very important that we're selecting somebody and we're not ending up in relation to an application to the court. And again, at a very stressful time, those court applications can be very stressful. I've seen through SAGE advocacy, again, where a person, when the mention of court to them, they get very distressed. And of course, it's not like a normal court procedure. At the same time, really important that we plan in advance. So coming back to then the power of attorney, a person can make an enduring power of attorney. It is registered within 3 months of execution under the 2015 Act, under the new legislation, and it comes into effect then when the person lacks capacity. A notice is served on the director, and the director accepts that notice that the person does lack capacity, and there are procedures to be gone through in that. A 1996 power of attorney is still very valid. and under the old 1996 legislation, that power of attorney did not become registered until the person lacked capacity. So there's a difference there. And of course, there's a huge advantage in the registration when a person has capacity. So any defects or any issues that arise can be clarified directly with the person who has capacity. Again, to emphasise that a person cannot make a health treatment decision in an enjoying power of attorney. I've spoken about the decision-making representative. Again, there's a procedure there. Notice must be given to the director, and it comes into effect only when the person lacks capacity, but there's no registration process. So again, coming to where a person's capacity is in question, again, decision-making assistance agreement, notice to serve on the director. And again, just to go into the website for the DSS, very clear templates and help and guidance on those. Co-decision maker does require a statement of capacity that the person does understand they need that support, and they understand they can enter into that co-decision making agreement. So slightly different requirements, but really important that people understand. Now, of course, again, just to note there at the end that a person can be in a position that they can make some simple decisions, but not make more complicated decisions. So it could be that they have different arrangements for different decisions. And of course, when a person lacks decision-making capacity, then an application is made to the court. Again, I stress, insofar as possible, the plan in advance should be made. And again, the court must abide by certain procedures provided in the legislation. A statement of capacity is required for the court application. Really important. The specific decisions are set out as to who the appointment of, in this case, is the decision-making representative to make the specified decisions. That decision-making representative is, again, a person who has obligations under the Act. So the applications to court should set out the benefit to the person, why a less intrusive arrangement wasn't put in place. And again, the application must inform the court of any other arrangements. There could be, as I said, an enjoying power of attorney to deal with some complicated finances, but this might be an application for simple decisions where the person lacks capacity to make. So just to say, it's really important we all understand the Act and the arrangements under the Act, and we use the Act insofar as possible. Again, another survey that Safeguarding Ireland carried out only last October, 83% weren't aware of the Act. So a high incidence. So hopefully we've made, and again, I know the DSS and the HSE and other organisations have been doing seminars and webinars about the Act. So hopefully we'll see a huge increase in that figure. Again, very low take up in comparison to with other jurisdictions. Only 11% have made an enjoying power of attorney, only 4% made an Advance Healthcare Directive. So we need to increase that. So again, I just saying that incidents of not respecting rights, and sometimes we don't even understand that behaviours are disrespectful or abusive. So just again to point out that making decisions without the consent of a person is controlling and abusive behaviour, making decisions against the will and preference of the person. And again, in many families unintentionally, in many cases, take over, make decisions, don't allow the person to participate or whatever, and don't assist them and don't support them to make their own decisions. Really important. The Act is really important on that. Person must get support. Also, as an aside, just to say, it's not really an aside at all, Ireland signed the optional protocol to the UN Convention on the Rights of People with Disabilities it came into effect last November. That optional protocol gives the right to a person to, I suppose, communicate to the UN committee if they were not given the support to assist them to make their own decisions or to make a complaint. So it's important, again, that respect for rights and that we understand, again, the right of the individual to that support. Again, abusive behaviour, refusing appropriate medicines or treatment, placement in a care against the person's wishes. That is really a lot of issues arising on that at the moment. The use of incontinence wear for convenience of staff or whatever, and other matters there. So I can move on then to the Law Reform Commission's report. It sets out a legal framework, as I said, for adult safeguarding legislation. Discussions are already taking place within departments and cross departments about looking at the recommendations of the Law Reform Commission to enact adult safeguarding legislation. And what the report is suggesting, the recommendations, is imposing safeguarding duties and obligations of anybody who interacts, not only a service provider, but others who interact with a person who may need help and support, whatever. It again looks at, and indeed Safeguarding Ireland, even before the Law Reform Commission's report, were suggesting the establishment of an adult safeguarding body. So again, a single body to have statutory responsibility for leading and coordinating adult safeguarding practices. As you know, all departments, all agencies work in silos, and we don't share information appropriately when it's necessary, etc. So it's really important that we have clear reporting arrangements, and again, that organisations and services do have provisions where complaints and issues are addressed, and then we have a very structured situation where issues can be escalated, and the body that has responsibility to promoting health, safety, etc. of people. So again, the duties and obligations will apply not only to regulated bodies. Regulated bodies will be HICWA, HSE and nursing homes, etc., but unregulated services as well. There are many. And just to say, of course, safeguarding is not confined to health and social care facilities or services. It's widespread throughout. So we need that adult safeguarding legislation for sports bodies, community services, everything. So really important. So in conclusion then, just to say, we have made progress in Ireland in recent years in recognising rights. Considerable challenges and forthcoming though still persist, and we must address those. Again, the social and cultural infrastructure does not adequately address safeguarding concerns. We still culturally, we still haven't moved into that space of respecting those individual rights and really supporting a person who is really challenged, not only a person who lacks capacity, but those who have capacity, but maybe in very challenging situations and very challenging living arrangements. So again, I just end by saying there's an urgent need to have a robust legal adult safeguarding framework. So I would urge everybody, one, to use the Act, use the tools that are there, tap into the Decision Support Service with the various information that's there. And again, just talk about the need for that adult safeguarding, but more talk about it, take action insofar as you can to ensure that we get a proper framework for adult safeguarding. Many thanks.
Patricia, thank you very much for sharing so much valuable information and advice for our for the general public and for the professionals who are attending this lecture now online with us, and also those ones who will view the recording. Just to let everyone know that a recording of this lecture will be available on the IGS website later today, we hope. So thank you again to our speaker, and I would like to welcome the panel members. And I think I'm just going to introduce firstly Anya Flynn. She's a solicitor and a former senior partner in the Dublin firm KOD Lyons, specializing in public interest law. And since in October 2017, she was appointed inaugural director of the Decision Support Service under the Assisted Decision Making Capacity Act 2015. You're very welcome, Anya. Also with us, we have Amanda Casey, who qualified as a social worker in Trinity College, and she was appointed the first chief social worker for the HSE in August last year. She is currently an adjunct assistant professor of social work in the School of Social Work, Social Justice and Social Policy at University College Dublin. Amanda, you're very welcome. And the third panel member, Dr. Rosine Corey. She's a consultant geriatrician in general and internal medicine in Tala University Hospital. And her specialist interests are medical and capacity law and peri-operative medicine. You're very welcome, Rosine. So we have a number of questions that we've received before the lecture, and some have coming in since the lecture started. So please keep the questions coming. We would have approximately 20 minutes, I think, or thereabouts, for questions to our panel. And I'm going to start by a question to Amanda. Amanda, if you don't mind to tell us a little bit about the critical work the safeguarding teams are doing around the country.
Great, thanks, Viviana. Yes, so as some people who are on watching the lecture may know, there are safeguarding and protection teams in each health area within the HSE, and those safeguarding teams are led by social workers who essentially are there to respond where a member of the public or a service user or somebody who's living or receiving health and social care has a concern that either they or someone that they care about has been harmed or abused by another person. And what will happen is if a concern is received by the safeguarding team, they will actually kind of meet obviously with the individual themselves, gather as much information as they can, and ensure that the service or the individual themselves receives the safeguard that they need. I suppose at a basic level, what we want to do is to try and prevent harm occurring in the first place. And I think from my perspective, I suppose as the chief social worker, I would see that there are kind of almost three tiers of responses. One, I suppose at a societal level, we can all, and as Patricia mentioned, the best way that we can kind of prevent harm is to ensure that people understand what our will and preference is and what our wishes are, so that we're involved in as many choices about our care as possible. And I think everybody within society has a responsibility and an opportunity to sort of have the tools that they need to protect themselves from harm. And there are things like Patricia mentioned around having an Advance Healthcare Directive and power of attorney, so that those around you know what your will and preference is, and are therefore less likely to make choices that might cause you harm. I think then the next tier up, I suppose, where the HSE starts to sit to kind of to fit in and to provide those level of supports. And that's really around ensuring that people who may need assistance to vindicate their rights are actually supported to do so. And in some cases within health and social care services, that's about perhaps using a speech and language therapist, occupational therapist, to ensure that someone is supported to communicate what their will and preference is and what their wishes are. And again, that's another way in which we can ensure that the person remains at the centre of everything we do. And then I think at the kind of the higher level, as you mentioned, Viviana, unfortunately, where harm does occur, the safeguarding and protection team then are the professionals who have the training to actually kind of step in to support the person, to investigate and to navigate what are often complex situations within families or within services, to ensure that the person both is heard and listened to, is respected, but is also given the opportunity to live a life free from harm and abuse.
Great. Thank you so much, Amanda. I'm going to move on to Anya. There's a question that came from Joan, no, it's actually the question from Paul. Is there any update regarding the implementation of the ward of court legislation and its implications?
I don't know what that means. Do they mean the Part 6, perhaps? Part 6 of the Assisted Decision-Making Capacity Act, which relates to the review and discharge of wards. This isn't something that we manage. This is the business of the Office of Wards of Court and the Wardship Court, and the Decision Support Service isn't directly involved. What we do know from our collaboration with colleagues in the Office of Wards of Court and the data that is available is that the numbers that have exited from wardship have been quite low. But nonetheless, the Act requires that all persons who are wards of court, who are adult wards of court, are to have their cases reviewed and to exit wardship. And the timeline is still in place that is to happen by April of next year. I think that there were something like 2,300 adult wards as of April 2023, and the number is still, and I'm sorry, this isn't my data, so it's from memory, something like 1,800 or 1,900 adult wards of court currently. So that process still has some way to go, but information on that is available from the Office of Wards of Court, and the resources setting out what the process is that's involved.
Okay, and there's another question for you, Anya, here. It's a question that came in from Clina. She says there is an EPA set up in March 2020. How does this differ from the new decision, from the new system, and is this still valid? And how can she add in medical requests to her existing EPA?
And Patricia has touched on this. Anybody who made an EPA before the 26th of April 2023 made an EPA under the Powers of Attorney Act 1996. They are untouched by the Assisted Decision Making Capacity Act, as Patricia has already said. They are still valid, and the processes under the 1996 Act continue to apply, so that should the need arise, and if that EPA needs to become operational, registered under the old Act, then the application is to court. I think then the question goes on, how can I add to it? Patricia will keep me right, but you couldn't put medical treatment into a 1996 EPA either. Personal care didn't extend to a treatment decision. So the opportunity for somebody who has capacity is still there to make an Advance Healthcare Directive instead. I'm answering the question.
Yep.
Okay. We see another question from Noel. Is there an alternative to enduring power of attorney if you don't have anyone to ask to be an attorney?
Oh, yeah. Well, you do need a trusted person, somebody that you're going to, and I have encountered this question a bit from people saying I'm quite alone in the world. There's nobody I can think of, nobody who would be able to step in and become my attorney, nobody I can name in an EPA document. So there isn't a panel of such of people that you can name. I was speaking to somebody only yesterday who said because her family are largely not close by or resident in the country, that she was sort of socializing the idea among friends to see whether one of them might be prepared to be named in her document. But yeah, by definition, an attorney is somebody that you know and trust is going to be able to step up and take important decisions for you should you lose the ability to make those particular decisions at a later time. So if you became instead, in the absence of advanced planning, the subject of an application to court, which is something that I suppose everyone would seek to avoid, but if that happened and if there was nobody able to be appointed as your decision-making representative, then the court might turn to the DSS and ask for nominations from our panel of DMRs. And there are professional people available to be appointed in those circumstances.
Okay. And if I could just add to that, Bibiana, obviously the court would look to the contents of an enduring power of attorney that was there, if it was made, and obviously direct the person appointed to work in accordance with that, because when the application is being made to the court must take into account any enduring power of attorney or Advance Healthcare Directive. So a person can still be very, plan in advance and say what they want and set out their will and preference. Yeah.
And actually, that reminds me, one thing that we do find ourselves saying a lot to people making EPAs with us is do kind of future-proof your document if you can. Think about whom you might want to name as a replacement attorney in the event that the person that you name as your first pick becomes unavailable. Otherwise, should that person be unable, you would have to go back and redo your document. So we would do encourage people to think about naming replacement attorneys.
Yeah, I think we have a question for Roisin here. What is your view regarding the rights to die debate?
So I think that's ongoing at the minute, and I know there was there was a lot of talk about that. I think it's a very nuanced debate. I work in a hospital. I see a lot of people coming towards the end of their life. My own personal approach is that we try to treat them with respect and dignity and work towards their own will and preference in terms of what treatments and where they would like to die. But in that setting, as regards to kind of the further talk on assisted suicide, I'm not sure where I stand, where we stand on that, but certainly anybody that I treat, it's with respect, dignity, trying to facilitate their wishes towards their end of life when they're either in hospital or trying to get them home, and involving our colleagues in palliative care.
Okay, and I think a similar questions came from Ita. Who can make decisions on end-of-life treatment in the absence of an Advance Healthcare Directive?
So my own practice, and certainly that of most of my colleagues, would be to establish what the person's own wishes were with respect to decisions about I suppose when they're approaching end of life, any treatment decisions. We talk to the person themselves if they're able to have that conversation. If they're not able to have that conversation, we talk to their family members to see if they've ever had those conversations. Do they have an Advance Healthcare Directive? In practice, very few people coming through have an Advance Healthcare Directive, and I think Patricia would have reflected that in some of this research already. But certainly we try to establish what the person themselves would have wanted. And we make a decision. It's a medical decision that's made based on what the person themselves would have wanted and how we feel they would respond to the treatment. And so it's a medical decision. We do not ask next of kin or persons, designated contact people. We do not ask them what they would want. It is based on what the person themselves would have wanted and a medical decision with regards to treatment benefits and risks.
Could I just add to that as well, Bibiana, just to point out the HSE consent policy, which was updated in 2024. So it sets out in detail some of those issues. And again, in terms, it is a medical decision, and it recommends also consultation with another healthcare professional. And again, it's only then if there is disagreement, perhaps an application to the court. But the HSE consent policy is very detailed, also sets out again to be followed in what is to be followed in emergency situations and in relation to Advance Healthcare Directives, just to add to what Roisin had said. Yeah, thank you.
Okay, we have a question from Kathleen here, where when a person is the executor of, let's say, one of the parents' will and all except one siblings agree to sell the house, can the one person stop the sale?
Well, sorry. Will I answer that? Yeah.
Okay.
Well, just to say, if somebody is the executor, there has been a will, and it sets out the person then as the executor, as distinct from if somebody dies intestate. Then the Act provides that certain people can apply to the court and be appointed. But the role of an executor then is to collect in the assets and to distribute the estate in accordance with the will. Really important. Some wills may give a directive to sell the house, but even if it doesn't give a directive, the duty of the executor is collect the assets, pay the liabilities. First of all, make sure testamentary expenses are paid, then paid any other outstanding liabilities and debts, and then distribute the will. So the executor has that right. Now, in many cases, obviously, if there's a family home and it's to be, that the will again might say that it should be divided, or each of them should have a share of it. But even then, the executor has the right maybe to sell that if it's necessary to discharge liabilities or meet other benefits that are given in the will. So a family member doesn't have a veto. It's the executor that has the duty to administer. Now, in many cases, families will try and agree and come together as to the administration. But at the end of the day, otherwise, if a person wants to make a claim against the estate for any particular reason, they can do that. But as we all know, the cost of challenging a will is very costly. And of course, any benefit that the person is getting under the will goes on legal costs. So, but the executor has that particular responsibility, just like a person appointed under an enjoying power of attorney and advance. They're the person that are being given the authority to do whatever they've been authorised to do. So really important issue.
Very good. See, there were some questions coming in about the EPAs, and I see Anya has responded.
Trying to get to the
very good. Thank you so much, Anya.
Will I try and rattle through them quickly?
Yeah.
Okay, so has there been any progress with people's ability to put EPAs in place? And I have thrown into the chat some numbers there. In terms of overall numbers of the EPAs that have been registered with us, the DSS, under the new Act, as of the beginning of this week, that was 1,760, with a further 1,860 submitted and now being reviewed for registration, with no reason to believe that they won't also be registered following the 5 weeks that has to elapse for the notice parties to be able to raise objections, and then we'd expect that 1860 would also make it onto the register. So that's over 3,600 that have reached the stage of being submitted to us at least. And we have what we call active draft EPAs. There are another 4,500 of those, and that's a subset of a further 11,000 that are currently in draft on our system. In terms of overall support, I put into the chat, which I hope is visible to all, and I hope I've typed it correctly, our EPA help desk number. We have a dedicated team that just deal with EPA queries now, have been in place for some few months. So that's the EPA help desk at decisionsupportservice.ie. And there's also, that's our phone number. It's now a free phone number. If you ring and ask for the EPA help desk, you will get a person who just deals with EPA queries. And there was a question about solicitors. From what we are seeing, 73% of donors don't instruct a solicitor in the making of an EPA. 27% do, and that's fine. In those circumstances, we speak to the solicitor. So in that 73% of cases where people haven't instructed a solicitor end to end to make and register the EPA for them, they have nonetheless been able to get the solicitor's statement, which is an element of the EPA. And again, that's one query that we encourage everyone to bring to us if they're encountering difficulties in getting a solicitor just to do that statement. Do also contact the DSS.
Great, thank you. Thank you very much. I think we will have a number of other responses put on as a part of the recording after this lecture, so that the attendees could get access to the information as well. There are a few other questions, but unfortunately we run out of time. So I'll have to just wrap up and thank you to our speaker, Patricia, Ricard Clark, and thank you to our expert panels for being here, for responding to the questions that came to the public. And I hope you all found it very informative, and the recording will become available later on today on the IGS website. Thank you all very much.
Thank you, everyone.
Thank you.